Jones versus Town of Carroll, on 7.
Counsel, you want to rebuttal?
3 minutes, Your Honor.
Go ahead.
Hey, please, the court. I'm Anthony Nosek. For myself and my client, thank you for granting us leave and allowing us to be heard.
So does Buffalo Crush Stone control here?
I'm sorry, Your Honor.
Buffalo Crush Stone?
Syracuse Aggregates is more apt, but Buffalo Crush Stone follows Syracuse Aggregates, so I would say I would go back to Syracuse Aggregates as the seminal case, but Buffalo Crush Stone certainly applies.
Those cases didn't have any zoning laws at the time the property was acquired.
That's correct, Your Honor.
That's not the case here. So how does that
That's
play
correct, Your
into your analysis?
Well, in many ways it makes it easier because at the outset, my client asked for a variance to be allowed to conduct a landfill on 50 acres of property. He asked for that variance. He was granted that variance. So there isn't a dispute from the outset as to what the variance covered. He could have put his landfill on any one of those 50 acres. Now, there are setback requirements.
Could he have gotten a DEC permit for all 50 acres, or were the DEC permits only done incrementally?
He could in theory. I think you have to understand how.
Three, the maximum at the time was
He got three, and he got them in stages, Your Honor. I think you have to understand why that happens. The DEC, you can in theory ask for anything you want from the DEC, but the DEC will only grant you a permit for a limited stepped, phased operation. And the reason for that is really very simple if you understand the DEC regulations. The landfill regulations are at 6 NYCRR Part 360, and they started being a few pages, and now they're immensely voluminous. What the DEC has done over time is, and as for that matter, in fairness to them, as environmental technology has developed, is they've developed more elaborate regulations. And of course, the bigger your landfill is, the more complicated your permitting process is, the more money you need to escrow for closure, the more money you need to escrow for unexpected events, the more complicated your operating plan is. And after you exceed a certain number of acres with respect to a C&D landfill, you need to put in liner. And liner is immensely expensive. So the advantage to starting a business and building a landfill business incrementally is you don't incur the massive expense of doing the whole thing all at once.
What's the relationship between what DEC does and what the town does?
Well, the town, I don't know that there's a particular relationship except that the town said you can landfill on this 50 acres to whatever extent the DEC allows. Now the town is trying to backdoor that requirement into saying that it can at any time extinguish the use at the time the DEC permit.
So it doesn't matter. It doesn't matter what the DEC says as to how many acres.
No, I don't think it does. The town said 50 is okay, and then you work with the DEC on your permits incrementally.
You're arguing the relationship.
I don't think there is a relationship.
It's what the town says, not what the DEC gives you.
Well, the DEC will continue to give us phased development as long as we meet the requirements of the regulations.
What the DEC does or what the town?
Well, the town gave it. It's important that the town gave us 50 acres. If they hadn't given us 50 acres, we would not have the use.
That's what I'm asking you.
If they had not given us the 50 acres, we would not have had the use.
And in Buffalo Crush Stone, the court looked at what activities had been done, because you can't just have it based on speculation that someone's going to use all their property. What do you have here in the record to support that there was an intention to use the entire parcel?
Yeah, I think we have a number of things. And these things, interestingly, and I think meaningfully, predate this law. First of all, we asked for 20 acres and we got it. Second of all, we bought bunches of equipment. We bought loaders, bulldozers, excavators, dump trucks. I know I'm missing something. Backhoes.
You had 12 employees at some point, right?
Well, currently, at the time the ordinance was passed, we had 12 employees. So the point is that these people built the business
You've got drawings going back to the 90s.
Yes, sir. I have a drawing, and the drawing is dated January of 1996 that depicts the entire property developed. Now, not all of it is landfill. Some of it is related uses, but approximately 37 acres of it is landfill. And I have a drawing dated January of 1996, which means that the plans were in effect in 1995. The variance was granted, I think, in 1989. Moreover, things were going so swimmingly here, that there came a point in time when the town changed its zoning ordinance. Now, at the outset, we were a nonconforming use. Then there came a point in time when the town changed its zoning ordinance to allow landfilling as a permitted use where we are on this entire 50 acres, subject only to a special use permit. So we then become compatible with the plan, compatible with the rules at that point in time. The only thing that I can analogize this to, and I think that would make sense to lawyers, is imagine if you were admitted to the bar and 16 years later the government came along and says you can't practice anymore. And imagine if that decision had nothing to do with the quality of your work. Imagine that you were an exemplary attorney, because that's what the facts are here. There is no complaint about noise, there's no complaint about dust, there's no complaint about odor, there's no complaint of any kind. There's no consent order from the DEC. What happens very, very simply is that my client begins to work, gets an investor, and the investor invests $250,000, his testimony is in the record, Daniel Bree, and he begins to do the work of taking the next step. Now you're above 3, you got to build liner. You're not going to build 1 acre of liner. It doesn't make any sense. You got to build more, because that's sort of the tipping point. And at that point in time, the town gets resistance. And it's very much the same as Syracuse Aggregates. Syracuse Aggregates, there was a sale. Things went along swimmingly until that owner got an outsider. And at that point in time, they got pushback from the town. It's very much like Syracuse Aggregates. Syracuse Aggregates was 5 acres out of a 25-acre site. They developed at the rate of about 1/10 of an acre a year.
Is there anything in the record that explains why the pushback happened? I understand it was public pressure, but what was the public unhappy about?
Well, they just don't want a landfill, Your Honor. I think it's that simple. They don't want a landfill in their town. This is the NIMBY phenomenon. It doesn't matter whether you run a good landfill or you run a bad landfill. It's a landfill. Look, there are certain uses that are publicly unpopular. And the politicians understood in this case that this use was unpopular. They were on board. I think there's ample evidence in the record, and I don't think it's contradicted by even the supervisor's testimony.
Is this landfill only for construction and demolition debris?
It's C&D.
It's just C&D?
Yes, it's C&D.
Not regular garbage.
Non-putrescible waste would be the lingo of the 6 NYCRR Part 360. They fall in 3 categories. They're secure for hazardous waste. There's sanitary for what we would call normal household garbage, which is putrescible waste. And there's construction and demo, C&D, for non-putrescible waste. C&D is the lingo, but it's
So are they burying the C&D,
yes.
or this is above surface landfill?
No, it's above surface. You don't put it underground, Your Honor. Essentially, the difference between a quarry and a landfill is that you're building a bowl. In the case of a quarry, the bowl is face up. In the case of a landfill, the bowl is face down, and that's the appropriate visual aid. They're both done under close supervision by the DEC. They're both done over a protracted period of time.
And they're both unpopular.
Oh, and they're both immensely unpopular. And I think that from our point of view, the Syracuse aggregate case is this case, and that's the case that decides it. I think thereafter, Buffalo Crushed Stone adds to the weight, and then I think also glacial aggregates, although it implicates different issues. In glacial aggregates, they never actually got into engaging in the activity. They never really did it. So this court in glacial aggregates came to a conclusion that at some point in time, you've invested so much money that even if you never actually got a permit and never actually did it, you have a property right. That is not implicated here. Here, we're very much the Syracuse aggregates case. In point of fact, there's fundamental equipment, the equipment I recited, the backhoe, the loader, the dump truck.
You're using the other property to support the 3 acres, right?
Oh, the other property has related, sure, it has a pole barn on it and has.
Right, I mean, those are various support.
And you recycle this stuff, so there are other parts of the property you recycle, but Your Honor, the variance was for 50 acres. We don't have that in these other cases. Our case is easy. We, from the outset, asked for 50 acres. Now, the question might be, would you have done it anyway if they'd have given you 10 or if you had given 20? Well, I know there's a point at which it doesn't make any sense to invest the money. The point is that Donald Jones and his family have got, they don't have what Buffalo Crushed Stone has tied up. They don't have what Glacial Aggregates. They have everything tied up in this landfill. This is it. In terms of investment, this is it. This is their entire life, their entire livelihood, and it's extinguished. It's extinguished like that because they can't pursue their next renewal permit. The other thing that I...
What happened to the sale, the purported sale, the prospective sale? What happened to that? That
Well,
disappeared?
Daniel Bree is in the wings. His deposition testimony was, my obligation is to pursue the permit if I can get one and if I can landfill. And in his deposition, he said, that's what he says. He said, my obligation is to pursue the permit. Now, he spent $250,000 and stopped, is where we are, because at this point in time, we're in the middle of this litigation, and it doesn't make an awful lot of sense to spend the kind of money that the DEC requires.
Okay.
But,
Counsel, now you'll have rebuttal. Your red light's up.
oh, I'm sorry, Your Honor.
Sure, go ahead. Counsel?
Please, the court. I'm Paul Webb. I represent the town of Carroll.
He can explain, rebut what he's saying, that they have a variance for the whole property. Why?
The variance that they have, one, is a zoning variance. So it's zoned so that they could, landfills are permitted in that area.
Yeah, but isn't the nature of this kind of process that you actually use it in phases? Isn't that how this works?
Well, you could, Your Honor, but it's
No,
not.
you could. Isn't that what you ordinarily do?
I don't know. It's certainly not like a quarry or if we
Why is it
bought
different? What's the
50
difference?
acres.
It is to the extent that you're holding the land in reserve. I mean, nobody's going to go in and buy a 2-acre parcel to start a landfill and then wait 3 years and then try to buy another acre and go back to the town and then buy another 3 acres and go back to the town. That's not reasonable.
A landfill is no different than, it's not a unique use of property like a quarry. I mean,
Well,
if
why
you-
not? Don't they both consume the land really over time? As
Well, they consume the land
You
the same-
extract and I guess you put, as he said, the bowls up or the bowls down, but they both kind of consume the land over a period of time.
They consume the land just like any other non-conforming use. If you had a non-conforming use, you would say to construct a 50-unit hotel. You had a hotel in existence, and you had plans to expand for another.
You're saying there should be a different rule for landfills?
No, I think it should be the exact same rule that we have developed. You look to see whether the use was lawful. And at the time, in this situation, the only lawful use of the property was the fact
Well,
that...
the DEC permit was only for the 3 acres.
Right.
But, again, they had a variance for the whole property that had support for what they were doing and the rest of the property. Why can you all of a sudden take away what one could argue is, that they acquired a vested right to the whole property? Isn't that what those cases are all about? Isn't that the question before us?
Well, you could not have a lawful use if it was zoned, we'll say, for a landfill. You could not operate a landfill without obtaining a DEC permit.
But didn't we say in Buffalo Crushed Stone that you don't have to have the permit to have the vested right?
You don't have to have a permit to necessarily have a vested right, but to have a lawful use, you certainly have to have the permit. The same reverse was the same with Town of Carroll versus Fruit Run Gravel. In that situation, they had a mining permit, and the town didn't permit it under their zoning.
You have to have a permit, what are you saying exactly? You have to have a permit for the whole property? Is that what you're saying?
You have to, the DEC regulates.
That you have to have a permit from the DEC for the whole property, and anything beyond that you could just take away from them? Even though they bought this whole property and have a variance for the whole property? Is that what you're saying?
The question is, what was the extent of the landfill on the date the ordinance?
That's not what I'm asking you. We know that they're working on the 3 acres and that they're doing support around it, but you're saying that their vested right is in the 3 acres, period?
That's correct.
On what basis?
Well, because
On what about our cases, all the cases we're talking about?
That is totally consistent with the rest of your cases. What you
With
do is you look to
Syracuse
see
and
the extent of the use. And the use, the only lawful use on that date was a 3-acre landfill, period. You couldn't use any of the remaining acres.
So the rest of the acres, for all practical purposes, were at your whim or decision as to whether to let them use it later, but they had no rights to the rest of the acres.
Well, the remaining acreage couldn't be used as a landfill. That's correct.
They had
without
no
a
right
DEC
to
permit.
use the remaining acres as a landfill.
Well, it could be once they permitted it, couldn't it?
Yeah, if they got a permit, it was zoned, no difference.
So how's that different from the mine that's developed in stages?
Well, with a mine, if you buy, we'll say the 50 acres was gravel. What you do is when the ordinance was enacted, you look to see what the extent of the use was. Now, if it was 50 acres of gravel, the courts have said, hey, that's a unique use of
But isn't the
land.
nature of this by phases?
Yeah, but it's no different than phases for any
If
other
you haven't gotten to
non-conforming use.
phase 2, phase 3, phase 4, and phase 5, it could
Right.
just be taken away from you.
Well, what did he say about the phases when I asked him about it? He said it was digging a hole. That's what he said. I asked him, what
What do
did you
our
mean by
cases say about the phases?
Well, the phases, you look to see what the use is at the time of the ordinance was enacted. What were they using for the property? You can't extend it. A municipality has the right to terminate that non-conforming use. That's exactly what we did. We passed a law to terminate the
You
non-conforming
can't get a
use.
DEC permit for that large a parcel. I mean, DEC is not going
why
to
not?
say we're going to give you a permit so that you can expand your landfill for 20, 25 years. The technology changes too rapidly. They don't, even in our mining cases, those
Well,
permits
is the same
are
rationale apply if you had,
renewable. They're not, you don't get one permit and it lasts forever.
But it's no different than if, as my example with if you had a hotel and you build a hotel and the municipality passes an ordinance, a restrictive ordinance saying no more hotels within this particular
But it's
zone.
not contemplated at the time. You submit plans, you're building a hotel. That's the hotel. Here, when you're doing quarrying or landfill, it's contemplated that's the entire project.
Well, that's what they say. It was contemplated for 16 years. They applied for a 2-acre permit and they got a 1 acre. That is the only lawful
I
use.
guess we're saying, how is that different from our
From the
mining
gravel
cases?
Because when you have a gravel,
It's
you
the
buy
same
50
thing.
acres.
They have acres and acres and acres, and they've only developed a portion of it.
But if you buy a 50-acre gravel pit, or 50 acres and it's got gravel in it, I mean, the intent is you're paying up front for that land that has the gravel in it. You've got to get it out. That's not the same with a landfill. It's no different than the construction of a hotel. They DEC permitted it for 3 acres to put in a landfill cell. The capital investment goes into that cell for the 3 acres.
But I mean, what's troubling us, I think, is I can understand the hotel being confined to 3 acres. We're having some trouble with the idea of a landfill that's confined to 3 acres. Isn't there a difference?
Well, what is the difference? The extent of the landfill can be the extent of the hotel or a junkyard. It's no difference. Or a mobile home park.
Let's suppose, I'm going to switch for a minute. Suppose you're right. Suppose this owner never required any vested right at all. What in the record shows that there's a rational basis for the rezoning?
Beg your pardon?
For the rezoning. Forget about vested rights. What other than public pressure justified the rezoning?
Well, it wasn't. Obviously, there was some, if you want to say public pressure. They held public hearings, and a lot of people showed up and said they didn't want.
I'm not saying that prevents that's necessarily a major negative. But what else have you got to support the rezoning other than a lot of people were screaming?
The town's water supply. It's not a public water supply. Our public water wells have got trichlorine in it.
Is
We had the
there
state of New York
something in the record that supports the idea that this rezoning was to protect the
Well, we
water
passed
supply?
2007. It's at, I think, in the record at 402 of the record, the local law of 2007, which is the waste disposal law that actually prohibits landfills essentially within the town and wants the debris to go into the county landfill. The county was encompassed to spend $7 million on a landfill. Our water system and so forth had been affected by it, and we felt it had been better, to go into the county landfill rather than having a
What in the record says what you just said?
well, if you look at the local law, that's in, I think it's at.
No, what about the chemicals affecting the landfill? What in the record, or affecting the public water supply?
Well-
Where's there something in the record that that's attributed to a C&D landfill?
Well, it went to the county, it went to our planning board. Our planning board recommended that those, it should not be allowed within an agricultural residential district because of.
I thought you said there was
water.
I'm sorry, I thought you said there was something in the record that indicated, as part of the basis for the town's action, that there was a chemical contamination of the water supply that was attributable to this landfill.
I think it's 396 of the record is a local law, waste disposal law of 2007, which was
what happened in
enacted
2007? Your rezoning was 2005.
That's correct. This is a town-wide waste disposal law that was enacted that restricted landfills within the town. And part of the reasons that we did that was because of our...
Yeah, but the question is, do you have the right to do that?
Beg your pardon?
Question is, do you have the right to do that?
Well, under the environmental conservation law, but we have the right to enact stricter standards for landfills.
One other change of subject. How can it be that prohibiting landfills, prohibiting landfills in the town has no environmental impact? Sounds to me like it would have to have an impact.
Well, I'm not...
But you
we
did
didn't
a
find a
negative
significant
declaration.
environmental impact. We did not find a significant environmental impact. And we sent the proposed law to the DEC, the county planning board, our planning board. We held hearings on it. We did not get anyone that came in and said that there was the restriction.
But you didn't do an environmental impact statement.
We filled out the full environmental assessment form.
You did a negative declaration.
And we did a negative declaration.
I guess what's puzzling me is it just seems intuitively that having a significant amount of less landfill space around is something that almost has to impact the
Well,
environment.
the county, I just said, spent $7 million to develop a landfill, and we felt that that's where it should go.
That had C&D, a part of it was C&D?
Oh, yeah, sure. In fact, I mean, Jones, Carroll is still in business. They do garbage. I assume they take their garbage to the county landfill. And they talk about an investor, but there was never this Dan Breeze and Sealand Waste or whoever it is. There's no contract. They didn't have a contract with him. I mean, if it was so important, you would think that there would be some
Did
type
they
of a
invest
contract.
any money, the alleged purchaser?
Well, I don't know. I mean, they said in the record, Mr. Nozick said that they spent $250,000 in supposedly engineering, but not that I know of. I mean, the only thing that I know is they had an access agreement which expired. They never entered into a contract with Jones Carroll. There's no contractual rights with Mr. Breeze or Sealand. So I'm not sure exactly what their status really is. And Mr. Jones admitted in his deposition testimony that him and his son dug the hole themselves. I asked him about engineering, if there were any engineering expenses. In particular, I wanted to know exactly what you had spent at the time we adopted the ordinance. So I said, ask him if there was any engineering money, and he said no. I said, but this is at page 17 of our brief. But just so that I'm clear, you didn't hire an engineer or spend money to develop development of this property? No. And in talking about the phase development, I asked him about the phases that he had talked about. I said, question, in other places throughout your affidavit, you use the term phase 2, phase 3, phase 4. He says, just an idea of digging a hole. We fill up a hole. Then we move it to another. We expand. You know, you see it, its phase as far as that's concerned. It's just what we wrote down, what we call it, different operations of it. You could say another section or whatever you want to say. I mean, it just really means nothing. That was what Mr. Jones was saying. So when we enacted the restrictive ordinance to terminate the nonconforming use, we allowed the use to stay as permitted under the DEC. That was the only lawful use that could be done on the property, the 3 acres. If he, after his permit has expired, he's recouped the capital investment for that 3 acres. After that, we didn't want him going out and getting another permit. We didn't want it expanded. We wanted the nonconforming use terminated. We have the right to do that as a municipality. That's clear. We have the right to terminate nonconforming uses if we do it in a reasonable manner.
Unless he had a vested right, right?
Well, the vested right is what was the use at the date it was enacted. And the only lawful use was what was permitted by the DEC.
You're limiting it to the 3 acres as
The 3
opposed to the
acres.
6. Okay, we understand your
You
position.
know, you couldn't do anything more. And if he was using other parts of the property to support it, it wasn't lawful. How can you use property in an unlawful manner to grant a vested right? You can't. And municipalities have to have some means to determine, you know, what's vested and what isn't. And if you look at it, what's lawful at the date of the ordinance was enacted, that is a cutoff. You know, and that's what we've done for years. We've looked at what's lawful.
Okay, counsel. Thank you. Counsel?
I have very brief points. If Mr. Webb is right, does that mean that every landfill use can be extinguished by the host town at the end of their current DEC permit? Or it sure seems so to me. And what a mess that would create. The other thing I would like to call to the Court's attention is language from this Court. It's an old case, 1960 case, Udell versus Haas, but it's a good case. And the language is this. The comprehensive plan protects the landowner from arbitrary restrictions on the use of his property which can result from pressure which outraged voters can bring to bear on public officials. There is danger that zoning may terrorize individual property owners. And isn't that prescient? That's exactly what happened here. They caved to the pressure and decided they were going to extinguish this person's property rights. And the notion that there was no plan is contradicted both by the zoning application and by the plan which is in the record. As for the 2007 law, I asked that that case be joined at the appellate division. The town opposed, saying it was a different issue altogether. Now, all of a sudden, they seem to be saying that there is nothing. Let me repeat, there is nothing in this record that suggests this landfill was leaking. Moreover, as part of an expansion, what's in this landfill site will now move over a composite liner, and that would be an environmental improvement. And if the town was concerned about its water, they'd be looking for that. Finally, I've been at this, the practice of law, since 1972. Some of you have been at it longer, but I've taken hundreds of depositions. I've had a lot of smoke blown up my suit in the course of those depositions. In this particular case, the supervisor, in a remarkable example of candor and truth-telling under oath, says this, and I quote, in response to a question of mine, I mean, if the town board had the authority to pull the rug out from under him, referring to the Donald Jones, they wanted to do that. That's what they did. But now the rug is in your hands.
Okay, thank you both. Appreciate it.